Hello, welcome, and thank you for joining me at something that is very close to my heart, and that is the art of witness statements. Now, essentially, there are two major components here. First of all, the straight law, but and we'll look at that in opening, and then the art of drafting and the practical and the tactical. So that is really where it all sort of comes together. So witness statements I grew up with. I was very fortunate. I was in fact involved in the exchange of witness statements before it even became mainstream in the courts, because there was a special practice running in what is today the TCC, back then the Official Referees Court. So I've been living with witness statements for longer than many of you have been alive. Hard to believe, but honestly, that's true. Anyway, so for beginners, witness statements are the lifeblood of litigation. Why? Well, they contain the evidence that your client and your supporting witnesses are going to give at the hearing. And obviously, if you don't have a statement at all, there's no evidence. If you have statements and they are inadequate, then you're not getting your message across. And therefore, cases that are perhaps unlosable could be lost if the statements are defective. So that is really what it is all about. Now, very quick history lesson. There was a time when we didn't have exchange of witness statements, which meant that you go to trial and you know the other side, because the court was there, right? You can have three witnesses each, whatever. You'd know how many witnesses were on the other side. You would have a clue what they were going to say. And that could be, I mean, sometimes it could be traumatic, and you could be wiped out. And so the model developed of exchanging witness statements in advance.